6-0. Is there any objection to taking up the PCS? Without objection, take up the PCS. Senator Young, you're recognized to explain the PCS.
Thank you very much, Mr. Chairman. Thank you for hearing this bill today. Members, this bill codifies well, let me back up because it's very basic. The bill specifies that the collection of impact fees, which frankly I support, I think impact fees are good. They help offset development. The bill specifies that the collection of impact fees will be made no earlier than the issuance of a building permit for the property subject to the fee. It also codifies the dual rational nexus test that we talked about earlier in Senator Perry's bill. This is set forth in Hollywood Inc. versus Broward County out of the 4th DCA. The test says that an impact fee has to, 1, accurately reflect the real impact caused by a development, and 2, that the fees collected must actually be spent on projects to mitigate the impact. The bill specifically states that impact fees cannot be used to pay off debt from prior existing projects. With regard to sector planning is a tool for creating long-term master plans on large acreage tracts of land over 15,000 acres. If local governments wish to impose a condition on a development order which implements a sector plan, such as the contribution of land or right-of-way, extension of public utilities, construction of parks, then the government must have ordinances in place to treat developments outside of the sector plan in a similar fashion. In short, it is an equal protection issue. A rational nexus must be included to show the potential impacts made by the development, and a reasonable time standard for local governments to timely process and act upon applications for detailed specific area plans. Basically what this does is take the concepts and language from the old DRI statute and put it into this section of statute. And that is the bill.
Thank you. Having explained the bill, are there any questions? Senator Powell.
Thank you, Madam Chair. Senator Young, what is the purpose of a sector plan?
Thank you, Madam Chair, and thank you for not requiring me to go through the chair. I know that you're a land planner, I'm a land use attorney, so we can speak the same language here. Sector plans, and I actually was a sophomore in the House when this was first enacted. Former Speaker Chris Afuli had the sector plan bill, and sector plans basically have replaced the concept of a development of regional impact, or a DRI. So they provide for advanced land planning and then implementation of that on very, very large pieces of property.
Thank you. And in your explanation, you indicated that you believe that sector plans should be treated equally or fairly in terms of impact fees to areas outside of sector plans. Can you explain the rationale?
Yes, absolutely. The concept was set forth in Kuntz versus St. John's Water Management District out of the Supreme Court. And basically, it is not sound public policy if a local government imposes one set of burdens on one type of development and does not impose equal or similar burdens on other developers. So for example, if I have an 18,000 acre parcel in your county, and Senator Bracy has a 5,000 acre parcel 5 miles down the road, the burdens placed on those developers should be equal, should be the same, and should be rational.
As a follow-up, with regard to that, so if Senator Bracy's parcel is all commercial, and then he's got 5,000 acres of commercial area, and then my parcel is 18,000 acres of part industrial, commercial, residential, and conservation, you still believe that with the different zoning designations or land use designations that they should be treated the same?
No, that's not what I'm saying. What I'm saying is that the impact, if there is an ordinance that requires impact fees to be paid to offset the impacts of any development, that those impact fees and the ordinances implementing them should be applied equally. So in your situation, Senator Powell, your residential particularly would be having significant impacts on schools and other things, where Senator Bracy's development would have no impacts. And so an ordinance dealing with school impact fees would have no impact on Senator Bracy's parcel. It would only impact yours.
And my last question would be, the sector plan, you indicated that it ties directly into the DRIs that we've eliminated. So since the sector plan would tie directly into a DRI, my understanding would be that it would be a special designation that you have, and there's a reason that this, say, 18,000 acres is in the sector plan. So since that there's a special reason it's in the sector plan, wouldn't it deserve special treatment?
I don't believe so.
Okay, thank you.
All right, any other questions? There are two amendments. Take up, I'm sorry. Senator Stewart, you're recognized for a question or a series of questions on the underlying bill before we get to the amendment.
Thank you. I see we had a change in leadership here, so I can see myself being missed. I have a question regarding the bill, and that, we have mega developments that are moving forward all the time in various counties, and the impact fees paid somewhat in advance pays for the roads and the schools and those type of things that we need to move forward on the project. So how does this bill, if it does, affect that advance payment for them to get started?
Thank you, Senator Stewart. And we have been working with the cities and counties on the timing of those impact fees because, as I stated earlier, I do believe it's important for developments to pay impact fees to offset their actual impacts. The question was really one of timing, and it's at what point are the impacts ready to be made or imposed, and so at what point is appropriate to charge the fees? The bill started out with certificate of occupancy as being that appropriate point. In talking with the parties, that was too late because once somebody's about to occupy a home, the impacts are already there. So in working with the parties, we moved it up to the issuance of a building permit. So that gives time to collect those fees. And we've also made many other changes to the bill to reflect concerns and specific situations in cities and counties to address their concerns. And I don't believe that they have, they can speak for themselves, but I think that they are all satisfied at this point with the timing issue.
Thank you.
Okay, we're going to move to the amendments. There are two. Take up Amendment 841860 by Senator Young. Senator Young, you're recognized.
Thank you, Mr. Chairman. This amendment is primarily technical. It clarifies that the collection of impact fees may not be required to occur earlier than the issuance of a building permit, and the local government must specifically earmark funds collected from the impact fees for use in acquiring, constructing, or improving capital facilities.
There are no appearance forms on this amendment. Is there any debate? Senator Young, you're recognized to close on the amendment.
Waive closed, Mr. Chairman.
All in favor of the amendment say yay. Yay. Any opposed? The amendment is adopted. Take up Amendment 532634 by Senator Bean. Senator Bean, you're recognized to explain the amendment.
Thank you very much, Mr. Chairman. Mr. Chairman, as you know, I represent Jacksonville, but also represent Nassau County. Nassau County has enjoyed Nassau County came to me a few weeks ago and said there is language in this bill that would eviscerate a local bill that this legislature passed last year concerning a development 24,000 acres in Nassau County. Nassau County passed, we all worked together on creating that local bill which sets the frameworks of how that development should go forward. It's already launched. That development has already been launched, and the first phase of that development has been approved, and Nassau County and the developer of that piece worked together to create a public-private partnership which built roads, a new school, and other infrastructure that is now underway. It is working, but they've sounded the alarm that the language in this bill would eviscerate and cause great harm to Nassau County. So this bill today, that language was put on Senator Young's bill earlier in the session. I am removing that language that Nassau County feels so strongly about. Nassau County, just a few minutes, you'll hear from the commissioners, which are united in opposition to this specific language. So this amendment removes sections 3 and 4 of the bill.
Okay, are there questions on the amendment? There are several appearance forms. Here's how I'm going to handle this. I'm going to allow an attorney for one side, and an attorney for the other side to have a 5-minute time limit on it. But before they are heard, there's several other appearance cards, and each of these individuals will have no more than a minute and a half to speak. Okay, so we're going to start with Commissioner Danny Leeper, Nassau County, BOCC. Waiving in support of Senator Bean's amendment. Justin Taylor, County Commissioner, Nassau County, BOCC. Waiving in support. George Spicer, County Commissioner, Nassau County, BOCC. Justin Stankiewicz. Pat Edwards. Chairman of the County Commission. All right, team, hold on. We're going to do one at a time. No, we aren't going to do this isn't law firm versus law firm. Everybody just in the normal order of things. Chairman, you're recognized.
Thank you very much, sir. My name is Pat Edwards. I serve as District 3 Commissioner for Nassau County and the Chairman of the Board this year. I represent approximately 81,000 residents and taxpayers in Nassau County. I stand here today in support of Senator Bean and amendment to SB 324. The Board of County Commissioners in a meeting voted 5-0 in support of Senator Bean amendment to 524. Anyone who's ever been a county commissioner knows a 5-0 vote is very difficult to receive. For 5 years, I've worked with and supported our partners, Raydient Incorporated and its subsidiary, Raydient Places and Properties, in implementing their plans to develop 24,000 acres into a sector plan. Since the 1930s, we have partnered together to improve Nassau County. HB 1075 was written by our partners and lobbied here to passage last year. The BOCC supported the stewardship through HB 1075, which provided language to help Nassau County grow in future years. Without your help, SB 324 will gut local HB 1075. Please support Senator Bean and his strike all amendment. Send the public-private partnership back to Nassau County using HB 1075, a local bill, to guide the development over the next 40 years. Thank you.
Mark Anderson.
Thank you, Chairman. Mark Anderson here today on behalf of Nassau County Board of County Commissioners, and it is with great reluctance I have to rise today and obviously supporting Senator Bean's amendment, but on a very good bill by Senator Young, who is not only a friend, but has a bill that we support, underlying bill. I just want to get briefly, Chairman, to why we're here and what this is about. It's not about Senator Young's bill. It's not about Senator Young. This is about Senator Bean's amendment and bringing the parties together. In 2011, Raydient asked my client to work with them to create a public-private partnership. They agreed not only to that request, but they engaged me directly to work with our legislature to create specific statutory authority for the board to enter into a partnership agreement with them wherein a master land use plan would then be created. The language passed and was approved by the governor in 2011. Moving forward, Raydient, a subsidiary of Raydient, then asked my client to convert the master land use plan to a sector plan. My client said yes to that and did so. Then Raydient asked my client to create tax increment financing to construct public roads. My client said yes and did so. Then Raydient asked my client to create separate mobility fees to be used inside the sector plan in order to fund public schools. My client said yes and did so. Then Raydient asked my client to approve a stewardship district to fund public facilities, including recreational parks. My client said yes. Not only did they do that, but they worked with Raydient to draft language to create the
30 seconds.
to create the local bill that Chairman Edwards just mentioned. The only thing they asked of the other side was to ensure that if taxpayer dollars are going to be used, that they properly mitigate the impact they have on public recreation. That's it. And from that, we found language in Senator Young's bill, and unfortunately, we're here today to have it addressed by Senator Bean's very good amendment. Thank you, Mr. Chairman.
Taco Pope. You have a minute and a half.
Yes, sir, Mr. Chairman. Thank you very much. My name is Taco Pope. I'm the Director of the Department of Planning and Economic Opportunity for Nassau County, Florida. I'm waiving in support of Senator Bean's amendment, but I'm more than happy to answer any questions related to land use planning and how it applies in Nassau County. Thank you very much.
All right. Sir, actually, if you come back up, no question? Yeah, maybe. Right. And Senator Gibson, what I'm going to do is we've got appearance cards, and then I've asked an attorney for each side, and I'm going to give them 5 minutes. And my sense is let's let that unfold, and then you can ask the attorneys the questions, and then after that is done, if you're still not satisfied, you want to bring somebody back up, then let me know, and we'll do that. All right?
Thank you, Mr. Chair.
Thank you. All right, thank you. Brewster Beavis.
Mr. Chairman, member of this committee, Brewster Beavis with Associated Industries of Florida, and I will be brief. Unfortunately, we stand in strong opposition to Senator Bean's amendment. First and foremost, this is good statewide public policy. What this does is simply take language that is currently in the DRI and move it over to the sector plan statute. This language has been utilized in the last several decades. I don't see why there's such a big, the sky is falling now, simply moving that language over. AIF went and asked for this language to be included. And to just clear up a couple of things, this does not do away with a contract between two entities. This does not do away with a local bill. This was not slipped in the dead of night, which is what some people have been telling me. We do oppose this amendment, as does the Florida Land Council, and we ask you to vote for good public policy for the state of Florida. Thank you very much, Mr. Chairman.
Thank you, Mr. Beavis. Okay, Susan Harbin Alford. In support of the amendment, Bar Association of Counties. Chris Doolin. All right. So what we'll do then is Gary Hunter is an attorney with the Florida Chamber and the Association of Florida Community Developers. Mr. Hunter, I'm going to give you 5 minutes, and then I'm going to ask Mike Mullen, who's the Nassau County attorney, to come up and give him 5 minutes. And senators, just if you're interested in this issue, I know we're all interested in all of our issues, pay close attention now, because I think this is going to kind of get to the root of the matter as to what each side is trying to tell us. So you're recognized.
Thank you, Chairman and members. Gary Hunter, I'm here on behalf of the Florida Chamber and the Association of Florida Community Developers. I will say that last year I happened to represent Raydient on the local bill that was referenced by the Commission Chairman. And let me go back and address that local bill first. Every local bill creating a stewardship district, and there aren't that many that have been created throughout the state, but if you have a stewardship district, you all create those legislatively. All those bills do is they say, here's the powers of this district. They don't obligate a district to do anything. The stewardship district then elects a board. That board then decides what powers of the powers that the legislature gives that district to exercise. And there are no obligations set forth, and certainly there aren't in House Bill 1075, which this body passed last year, upon that stewardship district to do anything within the powers that you create for it. You give it powers, it then goes back and becomes a pseudo form of government to exercise how it pleases the powers that you grant it. just like a city or a county does under their charter or the powers granted to it by the legislature. So to be clear, on behalf of my client last year, this legislation is a piece of legislation, I'm talking about Senator Young's bill, the sector plan portion of it, designed to address sector plans statewide. It is not intended to do anything to reverse what you did in a local bill, and in fact, it doesn't do anything to reverse what you all did in a local bill. You created powers for a district, a stewardship district last year that they can or can't exercise. Those powers include the right to build parks, the right to do lots of things within the parameters of that district, and it creates a burden upon those who own property within the district to fund those things. I don't think Raydient has any intent to not do those, to exercise those powers and do the things and enhance the district in the way that you granted it authority to do so, and this is not intended to undo that. On behalf of the Florida Chamber and the Association of Florida Community Developers and all the other sector plans that exist throughout Florida, this is pretty basic, good public policy. I mean, read what this language does that Senator Bean, my good friend Senator Bean's amendment would take out. This is one of the few times I've found myself, I think in all the years I've done this, and he's been here, that I disagree with him on something, but fundamentally, this language is pretty simple. It says if you have a sector plan, sector plans are developments greater than 5,000 acres in size. You all reduced that size from 15,000 to 5,000 acres after you did away with the DRI program. The point of reducing the size to allow sector plans of 5,000 acres is to allow good planning on big parcels. So what owner of a large parcel would come to a local government now if this amendment passed and say, I want to do a sector plan. I want to do a 8,000 acre project, 4,000 acres of which are going to go into conservation and have this partnership with my local government to create this magnificent plan and get it put into your comprehensive plan as a sector plan. Who would do that if a local government could treat a sector plan differently than they could treat another project? And the answer is no one. I mean, why would I advise my clients to come in and do a sector plan if a local government could charge a sector plan more exactions than its impacts were creating? And no large developer, no large landowner would pursue a sector plan. So the policy, the very good policy of the sector plan statute with this, Mr. Anderson is correct. You all put into effect in 2011. You modified it to allow smaller parcels to participate in it because you eliminated the DRI program, would go away in effect because nobody wanted to be part of a sector plan if a local government can charge you more than your impacts. By the way, I think that's unconstitutional to do it as a matter of law relating to the Coombs case that Senator Young referenced. You all are reaffirming that both in the impact fee portion of this proposed bill and in the sector plan portion of this proposed bill. Mr. Beavis said one thing that I think is worth repeating. For 30 years, this language has been in the Florida statutes under the DRI Act. For 30 years, it has not been a problem. The law says you couldn't charge DRIs greater impacts than you were charging projects that were they created, and you couldn't treat DRIs differently than you were treating projects that weren't DRIs. The sector plan program is the substitution for the DRI program, which no longer exists. And this is an extension of that language that existed in Florida law for a long time into the sector plan program. It would be very bad public policy, I think, to treat sector plans differently and discourage participation in those programs. If you go look at the sector plans created throughout Florida, not just Nassau County. Nassau County is a good example. Half of that project, half of the lands in that 24,000 acre sector plan are conservation. And that's generally how it works everywhere across the state. You want sector plans to be approved. They're the best plans that exist for large area planning, and this would discourage that effort. Happy to answer any questions. Thank you, Chairman, for the time.
You're recognized, Senator.
Thank you, Mr. Chair. So, if I understood you correctly, you said that the base bill would not have any negative impact on where Nassau County is in its partnership with Raydient and Raydient and all those listed requests apparently that were asked of Nassau County. This bill doesn't impact their local bill.
Senator, I could answer that, Chairman, directly. Senator Gibson, what I'm saying is this doesn't reverse any of the powers granted in that local bill. Just to be clear, I think what the county suggested was that local bill created obligations. And what I'm trying to explain is the local bill didn't create any obligations that this would let Rainier or Raydient out of. What the local bill did was it empowered the stewardship district to go do certain things. And if it chooses to do those things, then and it is going to choose to do those things, then it does so by assessing the residents within that stewardship district. This doesn't let them, there was no obligation created by the bill that you all passed last year. That's what I was trying to explain.
And so by removing, because my understanding was there's an issue that's particular to Nassau County, but the amendment then would, as most other legislation does, impact an entire state and not just Nassau County.
That's right. So what the amendment, what the language in the bill would do is prevent anywhere in the state, sector plans are only in counties, they're not in cities. So it would prevent anywhere in the state, any county in the state, from requiring a sector plan to pay impacts, to do something, fix something, give a park larger than, build a road greater than the impacts that result from that project. That's all the language does. And Senator Bean's amendment removes that language.
Thank you.
Senator Monfort.
Thank you, Mr. Chair. Gary, is this a misunderstanding between the both parties, or is this is it a misunderstanding of what the intent of the bill is, or is there a genuine disagreement on the implications of it, and if so, what are those?
Senator Monfort, I can't speak for Nassau County. I don't think they come up here in bad faith. So I think clearly their perception of what that local bill did last year is different than what it actually did. They're not telling you they think it undoes something because they don't believe that. What I'm telling you is there was nothing in that local bill as a matter of law, and I've represented lots of stewardship districts on lots of bills over the years, and none of them obligate the district to do anything. And so the county's perception was that they were going to be obligated to build a park. Let's use that as the example because that's the one that's been talked about a lot. The power to construct parks is within that act, but not an obligation to construct parks. That obligation is resulted through the county and the developer as they go through the approval process, and then the stewardship district can use that district to fund its obligations. But those obligations shouldn't be greater than the impacts from the project. That's all I'm saying.
Thank you, Mr. Chair.
Any other questions? Mr. Hunter. Thank you, Mr. Hunter.
Thank you, Chairman.
Mike Mullen.
Morning, Mr. Chairman and members, Senator Young. We respectfully disagree with Mr. Hunter. We acknowledge his expertise, but Ray and I disagree with his legal approach. If that were true, then there's no other person here before you from any other sector plan. So his client, Raydient, who was the public-private partner for Nassau County, did not tell their partner they were introducing this amendment. Why? Why would they do that? Well, we believe it's because there became a difference between the public-private partnership and all the things Nassau County did to encourage that development and still wants that development. It's good for Nassau County. What's not good for Nassau County is the language in paragraphs 3 and 4, and it only pertains to Nassau County. You don't have any other speakers today talking about other sector plans. So keep in mind that these two paragraphs contradict the local bill. If that wasn't true, why would Raydient go to the author of the sector plan language and have that submitted in the bill? You should also know that when a funding disagreement occurred within the last 4 months between their partner, the Board of County Commissioners asked the Raydient representatives to come talk to their partner in an open public meeting to discuss any differences that may have arisen. They agreed. At the last minute for the February 12th meeting, they said, we're not coming. We will only come if it's on our agenda. We will not talk about funding. They didn't come to see the Nassau County Board of County Commissioners, their partner who helped create this great planned area. They said, then let's defer that until either the end of February or March. Well, we didn't know at the time this language was pending in this bill. We discovered it when our lobbyist discovered the language and asked me, how does this pertain to the local bill? It directly, and I can't say this strongly enough, from a legal standpoint, after 30-some years of land use practice and representing local government, it directly contradicts and eviscerates, to use Senator Bean's language, the local bill. If you were to adopt and go with his striking 3 and 4, we think Senator Young's bill is still intact with what was originally intended, and I certainly don't speak for Senator Young, but we do not think 3 and 4 is necessary, and it again contradicts. What would be the cost to Nassau County? Well, we estimate a minimum of about $25 to $50 million. That's coming from our OMB office and everything else. So this is directly going to Nassau County. And let me just tell you quickly what's in 1075. The primary aspect, the existence and use of such a special and limited special purpose local government for the East Nassau Stewardship District lands provide for the adequate mitigation of impacts and development of infrastructure in an orderly and timely manner, prevent the overburdening of the local general purpose government and the taxpayers. Now keep in mind, 163 was created, the broadened powers by Governor Scott and this good legislature. 163 allows for consultation between local government and developers. 380 did not. 380 was an exaction statute. 380 doesn't belong, that language doesn't belong in this good bill. And interestingly enough, there's only one paragraph of 380 that you're being asked to include, not the second paragraph, which puts the same back on an equal playing field. So again, we believe that the Bean Amendment certainly puts us back where we should be. Not before you with a dispute in a public-private partnership. We should be having this in Nassau County, Florida. The developer, our partner, should come to us, the Board of County Commissioners, not here, not by an amendment they don't tell us about, not by bringing you into this. It's not necessary. I don't think the good people and you were meant to be involved. Otherwise, we'd have 67 counties up here, I think, telling you what their partner is not doing. We don't think that's right. We would ask that you support that. And again, let me address quickly impact fees. The impact fees charged outside today, the ENCPA, are the same as those charged inside the ENCPA. So it has no bearing on the impact fees. We're not charging more inside than outside. In fact, the agreement with the developer says it has to be the same. And we've abided by that agreement for 7 years, even before the special act. I'll be glad to answer any questions, Mr. Chairman, anybody may have, and would hope that you would support Senator Bean in Nassau County.
Are there any questions? Okay.
Thank you.
We're going to ask if there's any debate, and then I'm going to give the sponsor of the bill, Senator Young, an opportunity to speak if she so chooses, and then we're going to ask Senator Bean to close on his amendment. Anybody in debate? Chair Young, you're recognized if you would like to address the amendment.
Thank you very much, Mr. Chairman.
Absolutely.
Clearly, I felt that this language was good public policy. I still do believe that. I think that it prevents litigation and provides certainty to both the local governments and those that wish to develop within various counties. But in deference to my friend Senator Bean and the very difficult position that he is in, I'm going to just let the will of the committee reign.
Thank you for that perspective, Chair Young. Senator Bean, you're recognized to close on the amendment.
Mr. Chairman, thank you very much for the time that you've given this issue to be debated and discussed. You've been more than generous. Members, I'll be honest with you, nobody likes to put their family dirty laundry out for everybody to see, and it's almost like a squabble among friends in Nassau County. Make no mistake, I think Raydient, and they have been they've been an outstanding corporate citizen. I've worked with them for many, many years, and I believe they are a great asset to Nassau County. I also support and work with all of my county commissioners who have also come, and they're the ones that have said, Bean, we need help, and that's why I'm before you today. 24,000 acre development. Think about how big that is. Maybe in your county it's not very big, but in Nassau County it is absolutely huge. We're a county of 81,000, and estimates of this development alone range from 55 to 70,000 residents. So it's big. We want to get it right. Land planning reform has been, we've worked on land planning before the last decade to allow local communities input and control over how that development goes forward. And if we were to allow some of the language in, then we would say it doesn't matter anymore. All developments are treated the same when we know the public-private partnership and what we've created is already working. The local bill is already working. So members, make no mistake, I have work to do. I have work to do to bring these parties together, and I am committed to doing just that. Senator Young, thank you very much. Although we may disagree on this, you've been so generous with your time as we've debated and discussed this, and I know the underlying bill that we aren't taking out is still great policy that I'm looking forward to support once this comes out. So thank you, and to the parties, expect Aaron to invite you to fancy coffee to bring everybody together, and let's work this out. So with that, members, I ask for your favorable support to let a local bill stand.
All in favor of the amendment say yay. Yay. Any opposed? The amendment is adopted. Back on the bill as amended.